NACDL is the association of the nation's criminal defense bar.
And welcome and good afternoon to everyone. If you're just joining us, I will say welcome to NACDL's 22nd Annual State Criminal Justice Network Conference. And if you are coming back from either the first or second session, then I will say welcome back. My name is Monica Reed. I have the pleasure of serving as Senior Director of Advocacy here at NACDL. We're glad you've decided to join us for today's free live virtual conference. We have brought together leading experts on criminal justice reform who will be discussing a number of pertinent issues, including the topic of today's panel for this last panel of the day, which is focusing on how to meaningfully advance pretrial and bail reform while combating misinformation. With that, I want to turn it over to our moderator. I'm really excited for this last panel of the day that's going to be discussing, again, sort of how to meaningfully advance pretrial and bail reform while combating misinformation. I think we've got a wealth of knowledge on this panel and a wealth of examples to pull from, even from my home state of Virginia, where we have advanced some smaller scale pretrial and bail reforms, but unfortunately have gone back year after year in just defending those reforms. So I'm really excited for today's panel discussion. I'm going to introduce the moderator and turn it over to her to introduce the rest of the panel. So moderating today's panel, last panel of the day, is going to be Rena Karefa-Johnson, who is the Vice President of National Initiatives at Forward.us. And so Rena, I will turn it over to you.
Thank you, Monica. I'm on the West Coast, so I didn't fully realize we were the last panel of the day. So we'll bring the energy, we'll bring the vibe, so you guys feel engaged, hopefully. Like Monica said, my name is Rena Karefa-Johnson. I'm an attorney. I work in an organization called Forward.us and lead kind of our national advocacy and engagement around criminal justice reform. But I have been working in kind of the field of criminal legal reform and specifically pretrial and bail reform for the last 7 years. I started my career as a juvenile public defender and reentry attorney in New York. As part of that job, I spent a lot of time on Rikers with the 16 and 17-year-olds caged there. And that's kind of when I started to think about if there are ways to bring my advocacy for folks held pretrial outside of the court. Perhaps most robustly, I worked on the New York pretrial reform, bail reform that passed in 2019 that has been the subject of a lot of controversy, but also the winner of a lot of freedom for a lot of people since then. I always say about the New York bail reform, I'm a big Beyonce fan. So Beyonce has this lyric that's like, you're that chick when you cause all this conversation. I feel like we really crafted a policy that won a lot of freedom. And I think most importantly, took a lot of discretion away from prosecutors and judges, which was part of the reason why the backlash has been so heavy. I also worked on pretrial reform in California. I've given written testimony for the United Nations Commission on Human Rights about pretrial reform. It's really something that is important to me, has been kind of at the center of my career. And I believe, to me, it has always been the most tangible way that we actually start to radically reduce incarceration, is demanding a world where we eventually end pretrial detention entirely. So that's me. We have an amazing list of panelists today. I would introduce them, but we are a little bit short on time and they know themselves better than I do. So to Brandon and David and Charlene, what I'm going to do is I'm going to ask you guys a first question. And then I'll ask you to introduce yourself before you answer that question, and everyone will kind of do that question together. That way, I think all the participants can kind of get to learn a little bit more about what corner of the pretrial freedom bail reform world you're coming from. So the question that I have for you is, can you name one thing that you think your campaign or litigation or legislation or coalition did well in advancing pretrial freedom and reforming our pretrial system? And one thing that you didn't do so well or that you would do differently if given another chance? So let's start with you, David.
The pressure is on. Thank you. My name is David Gaspar. I am the CEO for the Bail Project. Just a little bit about myself and what gave me a passion for this work. In 1996, at the age of 21 or 22 years old, I was sentenced to 21 years in prison. I took a plea bargain with an 8th grade education. I didn't really understand the process, and I couldn't afford my bond, and nor could anyone else in my family or my life at that point. What I came to soon realize was that my 21-year sentence was erroneous. It was wrong. I learned that because I got my education while I was in prison. I taught myself law, and I actually wrote and filed my own appeal and went to the state Supreme Court twice, eventually winning a new trial, and as a result, winning my freedom after serving 10 years in prison. What was most insulting about it is when I stood before the court again to be sentenced, my representation at that moment told me that I had already served 5 years longer than what I should have served as my max sentence to begin with. Now, why does that motivate and inspire me when it comes to the Bail Project and the work that we do? Not having the ability to advocate for self, not having the opportunity to tap in and become educated about what your options are beyond what is limited and available within a jail environment is very restrictive, as well as depressing, to be honest. And you feel like the only option that you have is to be able to accept what is being offered at that particular moment in order to find relief, in order to be able to move to the next phase or the next step to be able to, progress in life. And so for me, this work that we do is really important. When it comes to the Bail Project's work and our campaigns in advancing pretrial reform, one of the great things about the Bail Project that I really love and being part of is, yes, we pay bail to release people who are in a position of poverty or lack of means. But we don't just get them out of jail. We actually meet with them. We identify what their needs are, what is holding them back, what potentially could help advance them in life, be it with housing, be it mental health, be it substance misuse treatment. It could be employment. It could be a number of things as individuals, or even a combination of things. And at the Bail Project, being able to work with clients at that particular level, it informs us, it educates us, and it allows us, after bailing out thousands of people year after year, accumulating over 28,000 bails to date, we've now gathered enough information, enough evidence to be able to inform policymaking and demonstrate alternatives to cash bail. But our team also uses this evidence to engage in direct advocacy and public education to advance change that's rooted both in equity as well as in reducing the reliance on incarceration. We have advanced this conversation to such a degree that we are now having meaningful conversations about pretrial reform that are both significant and sustainable. And this is what allows us to continue doing our work. As we strengthen due process, as we guarantee access to defense counsel, as we are continuing to innovate the needs-based approach of our work, we're seeing that people are more receptive and more willing to step into that conversation and to be part of the solutions that we've been able to identify. So just really proud of that work, really happy to be part of that and for the team at the Bail Project. If there was one thing that I would say that, if I could go back in time and do differently, I would like to have leaned more into the conversation about public safety. Having knowledge that bail reform is not the contributing factor to the rise in crime or the deterioration of public safety in and of itself doesn't change much. We have to recognize that fear is a real feeling. It's a real emotion that people have, and that sometimes that fear can be paralyzing. And so by leaning in, by stepping into the conversation and not just saying that bail reform is not the cause, bail reform is not a contributing factor, please don't believe the headline, but look into the actual facts themselves, is not enough. You actually have to step into that space and you have to meet people where they are. The same way we talk about meeting our clients where they are and helping to uplift them, we have to meet our society and our communities where they are and help uplift them as well in this conversation. So if there was something that I wish we could have done better, it would have been that.
Thank you, David. I definitely we'll get more into that because I'd love to hear more about like what you think what that looks like and what that means, especially when you live in a white supremacist society and a lot of where people are is not where I personally want to be. Okay, thank you so much. Brandon, how about you next? Just a reminder, introduce yourself, and then one thing that you think one of your efforts or campaigns or litigation strategies did really well, and one thing that you would maybe change or do differently.
Thanks, Rena. And I was really hoping I would not have to follow David, but well, there you go. It really is an honor to be on this panel and see so many participants and a number of familiar names and organizations represented here for this really, I think, central question and issue for us all. In terms of my own background, I'm Brandon Buskey, he, him pronouns. I am the director of the Criminal Law Reform Project at the American Civil Liberties Union. I'm based in New York. I've been here, I'm getting into my 11th year at the ACLU, which is amazing for me to think about in several ways. Some of them good, some of them, we can talk about later. But I've been working on pretrial and bail almost my entire time here. And that actually, in many ways, grows out of the work that I did before I came to the ACLU. I was a staff attorney at the Equal Justice Initiative for a number of years in Alabama and working on cases of people on death row, children sentenced to die in prison. And our director, Brian Stevenson, who I know, all of us know, would often, talk to us about the presumption of guilt that follows all of our clients and affects all of our work. And it really struck me. And when it was time for me to move on from that work, I was really motivated to try to find a place where we could flip that narrative and working on pretrial and in a place where, at least on paper, you're supposed to have presumption of innocence and more legal protection seemed like a really useful way to come at this work, going from more of a direct representation job to an impact litigation shop at the ACLU. And plus, while I was in Alabama investigating cases and going out and doing interviews, we just heard all the time about these systems or lack of systems in many rural places, many not so rural places, where people were just being held indefinitely before trial, no access to counsel. Places like Alabama, Mississippi, and really wanted to get at that question, right? Just the state's authority to hold somebody at all, but certainly for these really prolonged periods without any help. This really doesn't work if there's not access to early counsel. And so in terms of work, I'm a litigator. I come at this from that perspective in many ways, and I want to talk about an effort that we engaged in Detroit, Michigan, around bail reform. And just to give some very, very quick background, we worked with our affiliate. We have affiliates in all the states, and they had a real focus on Detroit. Not because it was the worst in the state, although it certainly was extremely bad in terms of what we've seen in so many places of detaining people, almost all Black people, just because they can't afford to pay their way out of jail. It's obviously the largest jurisdiction court system in Michigan, one of the larger in the country. And the idea was that if we can make an impact here, we can help a lot of people in Detroit, but then also send a message to the state. There is a statewide effort, there still is a statewide effort at bail reform, and then also try to impact the national conversation. And so we went after the Detroit bail system in federal court. We also figured that in many ways we expected Detroit would come to the table a bit more readily because of the history there and the fact that we didn't think they'd want to litigate a case to the hilt. And we'd also didn't want to be in the Sixth Circuit. It's not as many of the circuits are very toxic if you're familiar with the federal court and its shift in recent years. But it was really an effort to try to get to the table and have a say in how they operate their bail system. And, long story short, it worked out. And I would say, there's a number of things that we did, and thank you for dropping the link in the chat. I'm really proud of in terms of process, guaranteeing right to counsel at the first appearance, and then for later appearances, making sure judges have to actually get on the record and give their reasons, and a presumption against money bail, unless there are actual reasons to impose money bail, but then even then, having to explore alternatives to cash bail before you get there. But really, one thing that I really internalized in my time here is, process only gets you so far, and it's really about those outcomes. And so in this settlement, we were able to get the city and the court system to agree to release rate targets, right? Outcome-based targets, where they have to release most people held pretrial, even if they were following the procedures. And that's really opened up a different way for us to hold the system accountable, right? They come in, they can say, oh, we filled out all the forms properly. And then we can say, but you're not hitting your release rate targets. So let's talk about what's happening in the video and why you decided to detain this person arrested on a simple assault, things like that. One thing I wish that we had done differently, and I still wonder how this would have happened, we've been in touch with groups on the ground, the local bail fund, which I know David's familiar with, about trying to build a better ground game. And so we were in regular contact with those groups, just giving them updates on litigation, trying to get their input, but just ultimately couldn't figure out a meaningful way to incorporate local input and feedback into the settlement itself. I think in part because it's just a heavy lift for local groups trying to engage on these things. And the court system was really opposed to, much more outside accountability. And thinking back, especially now that we're in the monitoring phase, I do wish we had more of that pressure point, right? Either through a court watching program or something where they were accountable not just to the lawyers in the room, but then also the people being directly impacted. So I do wish and hope that we can incorporate that better in cases to come.
Thank you so much, Brandon. Okay, and then last but definitely not least, Charlene.
All right, thank you so much. And I hate to try to follow everyone else here. So my name is Charlene Grace. I'm currently on the policy team at the Cook County Public Defender's Office. Cook County includes Chicago. So based in Illinois, and as I expect everyone on this call knows, Illinois is about to completely eliminate money bail on September 18th of this year after a 7-year campaign, primarily by community organizations. So while I'm at the Public Defender's Office now, the victory really belongs to the Coalition to End Money Bond and the Illinois Network for Pretrial Justice, which we still work with very closely, and which I was part of helping launch several years ago when they started back in 2016 and 2019. So I want to shout out those community organizations and drop the link to the pretrialfairness.org, which will give you resources about the Pretrial Fairness Act, the bill specifically, and moneybond.org, which has information about the organizing, which is really responsible for this win, as well as I'd say the global uprisings of the Black Lives Matter movement in the summer of 2020, without which we wouldn't have certainly the same bill that we have now that's about to go into effect. So there's so much to talk about, and I know we want to get to your questions. I'll try to say really briefly, as Brandon and David talked a little bit about the philosophy. I think, ending money bail is the headline demand. It's the thing that is flashy and that electeds on the progressive side want to say they did. It's also an entry point for talking with people who don't necessarily understand the system, because I think most people get immediately why relying on money is an irrational thing. It's not going to produce good outcomes, including good outcomes for safety, like David was talking about. But as we all know, the question for pretrial policy and for advocates like ourselves is what replaces a money bail system, right? Because if we eliminate money bail, we take away, it should be an option for release legally. in most places. That's what money bail is supposed to be. And we don't want to replace that with a system like the federal system where we're seeing 70, 80% detention rates, right? So that's why I think a vision that really centers pretrial freedom, pretrial release, freedom from not just jail and pretrial incarceration, but from surveillance and other harmful conditions that are imposed on people who are presumed innocent, and many of whom will never be convicted of anything at all, is so important and is such a a goal to keep in mind as we're designing and advocating for these policies. And to that end, I think a couple quick notes on what's going to happen in Illinois on September 18th is that it's not just an elimination of money bail, right? Because that wouldn't have gotten us as where we need to go, but it's a wholesale redesigning of the pretrial decision-making process in Illinois. And that is going to result in mandatory release for the majority of people who are arrested every year, right? And defense attorneys and advocates here know, like, the majority of people arrested in any given place are arrested on lower level things. So misdemeanors and things like that, but also some of those lower level felonies that are going to not be eligible for the state to request detention right then after someone's arrested. So in Illinois, that includes drug possession, simple drug possession cases, which are the lowest level of felony. It includes driving on a suspended license. It includes retail theft, which are some of the highest volume kinds of those low level felonies where people are being ordered to pay money bail now, being released on paper while actually ending up in jail. And some other things that we're proud of, and I think are of interest to practitioners and defense practitioners, are things that are not always seen as part of the pretrial justice fight, but are very related. So as part of the reforms here, we designed a new system for handling alleged violations of pretrial release conditions and eliminated the generic violation of bail bond charge that people were being charged with for missing a court date, which was not only a new criminal offense that often resulted in the person being detained, but it was also set up to be a mandatory consecutive sentence. And so what it did was allow the prosecutor to charge that violation of bail bond, and then it just became leverage to force a plea on the underlying case and keep someone from being able to fight. So we eliminated that generic violation of bail bond charge, placed limits on electronic monitoring, and also made all of the previously mandatory consecutive sentences for new cases charged while someone's released pretrial or awaiting trial permissive. So unfortunately, not eliminating that possibility for consecutive sentencing, but at least making sure that it's discretionary instead of mandatory in every case. And one thing that we did well in Illinois over the course of this campaign, it came late, we should have done it sooner, but we did eventually get a lot of build a statewide coalition, because I think this is true for pretty much every state at this point, but we have really different court systems across the state, right? In Illinois, we have 102 counties, and we have basically 102 court systems or more, because to a certain extent, there's a different court system in every criminal courtroom underneath every judge. So it started out in 2016 with a coalition based in Chicago and sort of the Chicago suburbs, but expanding statewide in 2019, talking to organizers in other places, and in more recent years, getting feedback and doing revisions and amendments to the bill that heard from practitioners, defense attorneys, and other people in other parts of the state, really improved the law, because it is a statewide law and it is going to change for everything, for everyone. And one thing that we did well was ask for more than we thought we could pass. When we filed the first draft of that bill, working with our sponsor, who was a former organizer on the campaign, became a legislator, Senator Robert Peters, got to shout him out. And I think actually our sponsors were previous NACDL Champions of Justice awardees a couple of years ago. So we asked for more than we thought we could get, right? We tried to limit how much we were negotiating with ourselves, and that worked out. That ended up being even more important than it would be generically, because we filed that legislation at the end of 2019 or beginning of 2020, and then COVID happened and the legislative session stopped, and then George Floyd and Breonna Taylor were killed, and the Black Lives Matter uprisings that summer completely changed what was possible. And so we ended up passing something that was we had to a lot more than we had previously expected because the environment we were organizing within completely changed. And the thing we would do differently, or the thing I would say we do differently, is there were things we took out that we should have left in, right? There were actually places where we negotiated with ourselves and not knowing that those uprisings were going to happen. If we had had those in our draft, they would be the law now. But we took them out, right? And I would put like complete elimination of all pretrial fees in that category. So looking forward to the conversation.
Awesome. That was incredible. Thank you so much, Charlene. Just for our attendees to know, please feel free to start sending in questions. We're trying to leave a good chunk of time at the end for that. So if things come up or you start thinking about them, please feel free to leave them in the chat and we'll get to as many as we can. Y'all gave me so much to work with just now, but you know, I think perhaps what is interesting to have conversations about in kind of such a diverse group is like, we talk a lot about pretrial reform or meaningful pretrial reform or bail reform. And I think that it's always very interesting to think about like how we define those things or what those things mean in our actual efforts to reform the system. Obviously, knowing that we can't snap our fingers and change everything. I do think that one thing that is very kind of crystal clear is the narrative of a lot of opposition, which is basically like, this is unsafe, this causes unsafety, this makes us all unsafe, this is going to make more violence, more crime, which we have an extraordinary amount of data to disprove. But that narrative, that vision, that jail and specifically pretrial jailing makes communities safer is very crystal clear. And I think that that is part of what makes it difficult to contend with, because it's not really hard for folks to understand. And there's a lot of alignment alongside kind of opposition from mass incarcerationists of like what we all together are trying to achieve. I think that, you know, when we see the pretrial reform and the bail narrative, like Charlene said, it was really kind of penetrated, I think, into kind of popular culture, popular knowledge. I would say maybe around like 2017, maybe, like that's when we kind of started seeing on a national level folks talking about money bail or ending money bail. Kind of that's around the time when the story of Khalif Browder became a kind of a national outrage and a national tragedy. That's around a little bit later than that is when the National Bailout Collective started doing the Mama's Day bailouts. And there's a lot of talk about kind of like ending money bail. But I think that, like Charlene said, it's always been very clear for me, and I think for a lot of people that do this work, that the actual goal is pretrial freedom, that kind of making sure that pretrial freedom, if not afforded to everybody, is very much the rule. And pretrial detention is an exception. One thing that always struck me so much when I started practicing in New York was that from the New York State data in 2016, of like, I think it was around 40,000 cases that were charged as violent felonies, only around 25% of those ended in any jail or any prison sentence, which means that the folks who are charged with the crimes that are so frequently cut out of the bail reform deals or from the narratives, or like we maybe should have a different, just hard, we find it harder as advocates to contend with that narrative. 75% of those people are not serving time in New York on those accusations, period. So that means that the vast majority of people who see the inside of a cell on a violent felony charge in 2016 were there pre-trial, were there before any evidence had been presented against them. And I've always felt like if people can get down with innocent until proven guilty, it is very hard for me to understand how people can get down with pretrial detention, because that just doesn't seem to pass the laugh test to me, that you're innocent and you're sitting in a cage. But that leads me to a question, which is, how do your organizations define meaningful pretrial reform? There's like different ways to cut it. You can focus on the money aspect. You can focus on the judicial discretion aspect. You can focus on the freedom aspect. In New York, we did not end money bail with our reform. That money bail was still an option, and ideally, a mechanism for release. But what we did do was we created a huge bucket of charges for which release was mandatory. Judges couldn't say you are electronically monitored. They couldn't say, you're going to be incarcerated for this. You were mandated, except for small exceptions, to be released. And then we changed the law to make sure that there was an option of a judge. If the judge did set bail, they had to set an unsecured or partially secured bail or bond, which made it so that people didn't ever have only the option of working with like a predatory bail bondsman, losing their money, kind of trying to weaken that opposition. So I guess I will start with you, David, since you are the only person that works at an organization that is solely focused on bail. How does the Bail Project talk about what types of reforms are meaningful, and how do you articulate your vision for what pretrial justice looks like?
It's a complicated question to answer. To be honest, we work in multiple jurisdictions across the nation, and depending on where people are in their journey of comprehension, of understanding, of a buy-in and commitment to something better, kind of determines where the starting point is. So there's not a one size fits all, I guess, is the best way to answer that. But what I can say is a common thread, a common theme, is pretrial freedom is fundamentally the foundation of our American values of justice. If you go to our highest court of the land, the Supreme Court, you will find the words equal justice under law engraved in the mantle as you're approaching the court. As a free nation, the statement is our reminder. It's our North Star. It is our grounding point. And it's also the presumption of innocence that gives life and meaning to those words. Equal justice under law means that we treat everybody equally and fairly. So when we're talking about the cash bail and the disproportionate harms that causes, when we're talking about the inability to represent self or to advocate for your own defense, all these things are written out in very specific ways throughout our Constitution and our Bill of Rights. We know the importance of this as a nation. But what we also know to be true is that these words ring hollow each and every day for so many of us who have experienced firsthand the criminal legal system and its harms. We know that to be true. And so when we're talking to individuals, what we really want to do is just establish the foundation, the starting point. Because the reality is we're not starting at the same place. Those who are advocating for and fighting for us to uphold our system of justice as it was intended are not starting at the same place as those who have been fueling the propaganda of tough on crime, of the whole shake them down and lock them up philosophies. We have catching up to do and just leveling the conversation to be able to advance it forward. And so as I started the answer to this question, it's not a one size fits all, but it is the ability to go in and meet people where they are, give us and reestablish the foundation of our American values, what we all say that we stand for, what we all say that we want at every level of government as well as society, and begin the conversation in a very meaningful way that addresses the challenges that we face. You mentioned, public safety. I mentioned it earlier as well. When we're talking about public safety, we have to first and foremost be honest that bail was never intended to promote public safety. It was only ever intended to ensure that people come back to their court dates. So if it was never intended to be that way and it's proven not to be the solution, let's talk about what that actually looks like. But more important, let's define what is public nuisance versus what is a real safety issue. When we stop people because they don't have a seatbelt or because they're trespassing or loitering, because they are homeless, or because they are, stricken with mental instability or substance misuse disorder, all these things, jail is not the solution. Incarceration is not the solution. You cannot punish somebody out of mental instability. You cannot punish somebody out of substance misuse disorder. You have to treat these as they have been diagnosed and classified as medical conditions. Therefore, they require medical solutions, not punitive. And so when we want to talk about, what public safety looks like, when we want to talk about the purpose of bail, when we want to actually have a solutions-oriented conversation, we have to start to identify things for what they are and attribute solutions that are meaningful and sustainable to what those challenges are that we've identified clearly. But I just really want to reiterate that public safety has to be defined. We can no longer sit here and say that these items that we consider to be public nuisance are causes and justifications for taking somebody's life and putting them in jail for an indefinite amount of time until you release them back into the same conditions and circumstances that they were in prior to their incarceration. That is not a solution, never has been and never will be.
Absolutely. Thank you so much, David. Yeah, I think I spend a lot of time in conversations with people trying to explain to them that jail is not a housing policy. It's just not. Like, you can't pretend that the way that you house people who need housing or get treatment for people who need treatment is through jail. Okay, that was an excellent answer. So I think I want to ask one last question, then I'm going to hand it over to judges, and I'll ask it to both you, Charlene and Brandon. So as an advocate, there's a lot of different strategies that you can undertake. And I think when we see a lot of reforms that have seemed pretty stable or seem to have like a pretty broad range of coalition, like a broad range of stakeholders involved in the coalition to get them passed, you have to talk about like what narratives, what messages, what kind of policy priorities help get like quote unquote buy-in from the very decision makers that can undermine these laws in their everyday practices. So judges, prosecutors. On the other hand, there's a school of thought that any piece of reform that a prosecutor would want is not one that I would want. Or is maybe if there was an imperative from these actors to be invested in pretrial freedom, then we wouldn't have advocates because they would have had the power to do it all along. That's like a real big tension in this work. And I would just love to hear from both of you if there has been a way for you to find moments of kind of reconciling those two things, or very specific narratives or messages or messengers that you felt like have been useful in bringing some of those actors along.
I'll go first. And I, as I think about the bringing along law enforcement, including prosecutors, I also just want to add on to all of David's excellent comments about the safety piece, because I think it's really related to this. And one thing I'd say is that we've been really trying to own the public safety conversation, because we're like, we shouldn't be on the defensive here. Like, we have the better arguments, and it's part of how we talk about safety. And we're not just taking people out of communities where they already don't have what they need and then putting them in jail and then putting them back in the same conditions. We're actually putting them back in worse conditions, right? We're taking people who might have had a job or might have been in an educational program or might have been receiving care for some kind of mental or medical condition that they need support with. We're taking all that away and we're destabilizing their lives, and we're making sure they don't have a job, and we're making sure they don't have stable housing, and then we're putting them back in the community, because that's what pretrial jailing does to people. And when we talk about that and we talk about how that decreases public safety, it's very intuitive for the people who are open. And I think part of it is like, we don't have to convince everyone. And we want to convince a lot of people and as many people as we can, sure. But I think sometimes we get stuck in this thing where we feel like we have to convince everyone, and we don't. We need to bring along the people who are movable, and we need to bring along people who are going to organize and work with us. But there are people who are too rooted in white supremacy to ever care about the harm that we're doing to predominantly Black and brown and poor communities. And we're not going to spend our time on them. We might need to arm legislators or electeds or other people who have to respond to them, but we don't have to spend our time trying to convince people who aren't actually movable. When we have a lot of people we can reach with real arguments about public safety. And obviously that's what the data shows too, right? The data shows if you jail people awaiting trial, they're more likely to be arrested in the future because those people are coming back. And the question is, are they coming back in a better position or a worse position? So on the prosecutor side, like, I don't think we're ever, I don't have a way to reconcile that, Rena. I don't have a way to reconcile the certainly not with a vision where we're eliminating pretrial incarceration, right? Because we already had preventative detention based on safety in Illinois, right? That's a huge difference than New York and the landscape that New York is working with. And of course, you don't want to develop a whole regime for preventative detention when you don't have it now, and when you're legally not supposed to be making detention decisions based on safety. The reality is in Illinois, there was already a very broad power to detain people awaiting trial based on safety concerns, even though safety is a needle in a haystack, right? We spend all of these resources and all of this narrative time looking for cases in which someone's going to be released and then hurt someone else, when in reality, it's such a tiny percentage of cases, it's actually statistically impossible to predict. So I think part of it is trying to let people make different arguments for different audiences. That's part of what we've done with the prosecutors, the small number of prosecutors who support the reforms here, is to let them have the conversation about, before access to money was the main determination of who was in jail and who was released awaiting trial. And now we're going to make decisions based on the facts of a case and and spend more time on a smaller number of cases, because we're going to mandate release for the kinds of charges where people, and I think this goes back to what you were saying, Rena, at the beginning about Rikers and who was there and why they were there and when they were there, is that we have this narrative where people are demanding that there's the ability to jail people awaiting trial for misdemeanors, for the lowest level felony, for cases where people don't go to jail if they are convicted. But there is this narrative, both publicly and with legislators, that you have to have the power to jail people awaiting trial who you wouldn't even jail if they're convicted. So I think we have a ton of education to do, and there's sort of a relationship between this, but I think having different messengers with different messages has been helpful, especially if we're, feeling confident about the actual outcomes that those changes are going to produce in terms of jailing fewer people. I think that was a bit of a mess, but hopefully it made some sense.
No. The question was extremely chaotic. So you did a great job with it. Brandon, do you want to, no pressure, because we'll go to audience questions, but if you have something to say, I think in our prep conversation, you had some interesting insights about, like, what do you do about the judges? And if you want to share any of those, would love to hear them.
Yeah, that's where I wanted to go. And I think as a litigator, that's been, I was going to say, an honor I've had, or maybe a, pain in the butt I've had, is I've seen a lot of judges over my career, and so and just have been a lot of, and right, and so it's wonderful the way litigation in some ways shifts the conversation and shifts your pressure points with those stakeholders, whether it's the judges or if you're able to pull in the fiscal unit, the county or the city. But then, nobody likes being sued. And so then you're left saying, all right, we have to do something. As a litigator, I realize that the constitutional minimums that we can successfully get from litigation are often far less than what we actually want in terms of a functional system. So now we've got to bargain with judges to get something better than that minimum from litigation itself. And I think that kind of gets to some of your question, which is, right, we've got to figure out really kind of like an almost sort of just like a deep canvas situation of just like, what are your motivations? What are your concerns? And you find out, you have a lot of judges who really just don't have a lot of information about how jailing impacts people. And I've been surprised the extent to which that can influence, to some extent, their reaction to what we're proposing. A lot of things what a judge will ask is about, what do I do? Right? Just, how would you have me do this differently? Right? And being able to come in, I think as everyone has talked about with actual solutions and taking on the fact that, yes, we care about safety as well. We think we can achieve a result that does that with things that are way easier, way less costly than having people come into court so many times. And so we've actually, connected jurisdictions with court date reminder services, right? We've actually connected them with technical assistance from groups like Vera or others. I don't know if they want to be named, but we've done it and said, like, look, if you're willing to come with us, we will find a way to give you resources. I mean, we're not going to waive our attorney's fees, but we can figure out ways of bringing these things to you to try to achieve the same ends. And then you realize a lot of it, these folks see themselves as good people trying to do the right things in most cases. And so if you can appeal to that in a constructive way, right? Coming in and saying, well, the law is this and the best practices around the country is not going to go anywhere. But if it's, hey, let's talk through this and find solutions and do it in a way that we can connect at your level, we've had some degree of success.
That's awesome. Thank you so much. Yeah, it's an uphill battle. I mean, if you even think of like the design, like the architecture of the criminal legal system and the way that judges and prosecutors meet folks, the first thing they hear about them are these accusations. There a lot of people are coming in from the back, from the holding cell, having had a really, really one of the worst nights of their lives. Like it's a big uphill battle to overcome a lot of that design, to kind of try to shake people and allow folks to see folks accused of things as the full human beings that we all are. Okay, so we're going to switch to audience questions. We have a couple in here. I will start. This is from Mike. And this is for you, Charlene. The question is, does the elimination of monetary conditions of bail in Illinois mean that money can never be posted to secure release? In my state, release can be secured by posting property valued in the bail amount, posting 10% of the bail amount, or going through a bail bondsman. With the first two options, client or third party gets all of their money and property back if they show up. We got rid of cash bail several years ago. If we want to eliminate monetary conditions of bail, don't we force our clients into the hands of bondsmen?
Yes, so very quick and easy answer to that question in the context of Illinois, so we can keep getting to others, is that Illinois doesn't have a private for-profit bail bonds industry. It was eliminated in 1963, and we moved to a system in which people pay 10% of the cost of the bond amount to the courts directly. So that's not the case here, luckily. Obviously, there are a number of different kinds of money, bail, and payment options and different kinds of security that people can post, but for us, it was money to the courts. And I will also say it's really important, I think the ACLU and Color of Change did a report on bail bonds industry practices a few years ago that maybe we could dig up, that found the bail bonds industry wasn't actually paying the courts sort of when they should have been based on the agreements they've made or the representations they've made. And I'm saying that because even though we don't have bail bonds people, what's interesting is there's a narrative and people think it's intuitive and people have skin in the game because they put up that money and then they come to court, so they'll get that money back at the end. But in Illinois, when people actually researched it, what they found is that people do not get that money back at the end of their case. The reality is the courts keep the vast majority of the money that's paid in bond and they use it to pay fees and costs, and they keep it as a processing fee, and they do all these other things with it. And so this idea that people are going to come back to court because they're going to get that money back is relying on a false idea, because people don't get that money back. Aside from the reality that their accused people are overwhelmingly not the people actually paying it, it's their loved ones, and very often it's grandmothers, mothers, girlfriends. So.
Yeah, I'll just add to that I remember in New York, when prior to bail reform passing in 2019, New York was a state that allowed for charitable bail funds. So some of the first bail funds, which have now become much more widespread, were based in New York, and they would pay folks bail for them. And I remember that the appearance rates of the folks whose money were paid for by the bail funds was always higher than the appearance rates of folks that were released on their own recognizance, so had no money down or paid their own money. So I think that that's also been like useful for me to understand. That's also true right now in New York of bail reform, folks that have been released without any bail as a result of the reforms have the appearance rate in court is now higher than it was previous to the reforms. Okay, second question. I find, have any of you experienced success appealing to a more cynical audience by citing the cost of pretrial custody? It seems like taxpayers might be receptive to those arguments if 75% of folks aren't even convicted. Relatedly, if you've raised that argument, what are the counterpoints misinformation you've heard? I can start really quickly. I do think that that is compelling to people. I think increasingly, I have struggled with the fact that the way that the narrative about pretrial and bail and overall the criminal legal system operates is like often occurring in people's like emotional brains and not their rational brains. So I think that like in New York, we spent an extraordinary amount of time debunking a lot of the misinformation. I think New York bail reform is like one of the most studied pieces of reform in the history of the United States of America. Countless governmental studies, not even advocate studies, showing that only between 2 and 3% of the people released because of bail reform were even rearrested for a violent felony. Yet this narrative that crime is up, violence is up, that's because of bail reform has been really hard to disrupt. So I think to Charlene's point about like convincing the people that can be convinced is really important. But one like piece of advice I often give folks is that when I first started organizing, somebody told me like, never repeat the charge of your opponents. And what that means is like, if they're saying something, don't say it again, even to rebut it. And so I think in New York bail reform, we went from this like really rich, evocative, powerful narrative of like, look what this does to people. Look at the story of Khalif Browder. Like, look at all of these mothers mortgaging their house and losing their 17 generation brownstone in Brooklyn because they had to give it up to bail bondsmen. Like, this is not fair. This is not equity. And people are like, yeah, to like, oh, doesn't increase crime. Here's the data. What even is cashless bail? They're making stuff up and like completely being in a defensive posture that just was us continually saying what they're saying, even to say that it's not true. So I do think that like, it's important to be strategic about what messages you use at what point in a campaign with what audience. And it is very important, I think, to uplift the data that you have that supports your case. But I think very often campaigns shift to defensive, stop telling their own stories, stop saying their own narratives, and are continually responding to the lies. And I think on a macro scale, like maybe not on a micro scale if you're talking to an individual elected official or an individual judge, but on a macro scale, that just doesn't seem to be sufficiently powerful. Do any of you all have any thoughts about that specific point?
Very quickly, I don't think I would add anything to your specific answer, Rena. I would say on the fiscal argument specifically, I think I agree it can make inroads. I worry a lot about it in certain respects on the longer term trend because there's this carceral economics that you want to avoid, right? It's like saying, oh, well, okay, then that means we can only do reforms that do save money. And so much I think what we want in terms of real freedom, real thriving, requires us investing in underinvested areas, right? I think David gave a good list earlier in terms of mental health, education, all these other things that we think would be far better investments, but I couldn't say would necessarily cheaper in terms of how much we're spending now on them versus how much we should be spending. So I think you also got to realize when to break from that and shift into the kind of the broader vision of what you actually want to see achieved, so that you're not boxed in by that framing of we only do things that save us in the short term.
Completely agree. Okay, last question is from Nate, and Nate says, regarding the presumption of innocence, I find it helpful when combating misinformation to define it as innocent unless proven guilty. Our pattern criminal jury instructions in Washington state use unless rather than until. Is this true in other states? If so, can that be used rhetorically as a way to better explain this fundamental right? That's a good point. Does anyone want to take that?
I'll just say it is a great point, and it's actually not something I think I've heard, and I kind of want to take it up. So I appreciate, Nat, you raising it and suggesting it for all of us, because you're right. I mean, we say all the time, like, people think, you know, people think once you're if you're arrested, you're guilty, and people also think that all felonies are murders until you tell people like a lot of felonies are retail theft. But I think we tell people all the time that, like, in 2019 in Cook County, 40% of felonies ended in either not guilty or the case deemed dismissed or some other non-conviction outcome, and it's a huge number. And I think it really shocks people who aren't in proximity to the court system all the time. So it's just a great rhetorical point.
Anybody else? I love that. I also had not heard it. And now I feel extremely embarrassed that I've been saying innocent until proven guilty, because talk about carceral logic. You're innocent for this brief moment until you're proven guilty. So thank you, Nate, for maybe single-handedly saving the pretrial reform movement from itself. Okay. I mean, I don't think we have any other questions. So unless any of our panelists have any burning desires, I think we can end it here. Thank you so much to Charlene and Brandon and David, both for being here today, but also for the incredible work that you all have done. And thank you all so much for being in the trenches and fighting the good fight. And hopefully we can continue to kind of have this conversation outside of this Zoom space.
Thank you. Just to echo, want to thank our moderator and all the panelists for today's discussion. And as we promised, we are sharing everyone's contact information in the chat. So definitely feel free to follow up and continue to engage with each of them in terms of their work on pretrial and bail reform. Thank you for everyone for sort of joining us for day one of the conference. And I just want to quickly go over sort of day two on tomorrow, Thursday, August 17th. And so again, we'll be starting the day at 1 p.m. Eastern with the first session geared toward reverse and keyword warrant searches. And so you heard from Jumana Musa earlier today, who is director of NACDL's Fourth Amendment Center, but you also hear from her colleague tomorrow, Michael Price, who's litigation director for the Fourth Amendment Center, who will be leading that sort of opening discussion. And we also have panels dedicated to sort of drug decriminalization, looking at the efforts in Oregon, and then rounding out day two with a really in-depth conversation speaking to communications and messaging and narrative. And I know it's been touched on in this panel and others. And so really sort of bringing together comms and communications advocates to have that discussion. But even before we jump into our panels for tomorrow, every year for the past, I guess, maybe 12 years now, we have been sort of recognizing a state advocate or organization for their work to advance state level criminal justice reform. So even before we start tomorrow's panel discussions, we will take a moment to announce and present the 2023 recipient of NACDL's Champion of State Criminal Justice Reform Award, so it should be very exciting. So again, thank you for everyone for joining us. I do want to highlight, if you are a part of very similar to ACLU, NACDL has affiliates in about all 50 states. If you are a part of an affiliate, a leader, et cetera, in our affiliate organizations. Jessica Steppen, who's our Associate Executive Director for Strategic Marketing and helps sort of manage our affiliate relationships. So we'll be hosting sort of a networking event immediately following this conclusion of today's session. So at 5:30 actually. So at 5:30 Eastern, you should join us for that recognition event, and the information to RSVP is on the conference webpage. So follow that link and you can get the information on how to join us at 5:30. So again, thank you everyone for joining us for day one. I hope you can join us for day two, and we look forward to it.